All right, questions continue this morning after a Florida man was shot and killed during a dispute over a parking space. The shooter could avoid charges because of a stand your ground law in Florida. Let me walk you through what happened. Take a look. This is surveillance video from last Thursday, and it shows Michael Drake confronting a person who was parked in his parking spot, handicap spot. You can see the woman's boyfriend, Marquise McLaughlin, approach Drake, push him to the ground there. While on the ground, you can see Drake pulls out a gun. McLaughlin appears to back away a few steps. Watch this again. Drake fires, hitting McLaughlin. After McLaughlin is shot, he stumbled back into the convenience store, died in front of his girlfriend and his 5-year-old child. Now, Drake, again, leaves behind 3 children. Drake, who shot and killed McLaughlin, has not been arrested because of the stand your ground law in Florida. Here's how the Pinellas County Sheriff explained it.
He had to shoot to defend himself, and those are the facts, and that's the law.
Well, the framework of the Florida law says that the state has to provide, quote, clear and convincing evidence proving the shooter deserves to be prosecuted. It's pretty vague. At least 24 states have different versions of a stand your ground law. Our next guest believes the moment where McLaughlin backs away raises big questions about whether that law should apply in this case. With me now is criminal defense attorney Anthony Rickman. He's in the Tampa area. That's close to where this incident took place. Thanks for joining me.
Thank you for having me.
Let's listen to a little bit more of the Pinellas County Sheriff explaining why no charges have been brought.
It's a violent push to the ground. This isn't just a shove. I mean, he slammed him to the ground. And he said when he's on the ground, because he's in fear, that the next thing that's going to happen is he's going to be re-attacked by McLaughlin. And he felt that he was at peril and that he needed to shoot to defend himself.
Is that shove to the ground enough, do you believe, for stand your ground to apply here to protect him from prosecution?
Quite frankly, no. And in looking at what we see here and whether or not stand your ground law applies, it's important to know what stand your ground says. And what Florida stand your ground says is that if you are attacked in a place where you have the right to be, you don't have to retreat. You could stand your ground and meet force with force, including deadly force, if you have reasonable belief that there is imminent serious bodily injury or death. And the key term in the law is imminent. And what we see in that video, there's no doubt about it. It is a violent shove of Drake. He falls to the ground, he tumbles, may even hit his head. But after the shove, that's what's important. What we see is McLaughlin step back, almost disengage Drake. He almost he turns his body.
Yeah, and we see that. My question to you about the Florida law specifically, though, is that it's changed. It's actually changed and become a little bit more open-ended. And it seems to become even more sort of up to interpretation in terms of what you see. What's different now about the Florida stand your ground law from what it was?
What's different is in 2017, the Florida legislature changed the burden of proof. And they changed the standard on Florida stand your ground. Previously, it was up to the defendant to assert immunity under stand your ground law. And the defendant had to go to court and prove why he was in fear. The burden has since shifted in 2017 and now lies on the state attorney's office to prove by clear and convincing evidence that the defendant was justified or wasn't justified in killing. And basically, the change in the law forces law enforcement, forces the state to put themselves in the shoes of the defendant and say, was his use of force reasonable? And now the state has to show that he wasn't reasonably justified.
So on that point, just quickly, what happens now is that Florida state's attorney has to decide whether or not to seek a grand jury indictment, right? How likely do you think that is it happens? I mean, where does this legally go?
So legally what happens is the sheriff's office sends over all their information to the state attorney's office. The state attorney's office, through their investigators, conduct an independent investigation to determine what, if anything, to charge Drake with. They're going to look at the facts, look at the evidence, look at Drake's possible prior history, prior threats he made, look at the video, most importantly, and make a determination if they can meet their burden. And they're looking at it 2 ways. Number one, can they meet their burden at a stand your ground hearing, meaning clear and convincing evidence? Secondarily, can they prove at trial, if they meet this burden, beyond a reasonable doubt, that Drake wasn't justified in using the deadly force? And they can either take the case to a grand jury or charge him with what's called an information.
I appreciate you being here. We're out of time this hour, but thank you. We'll keep on this case for sure. Anthony Rickman, appreciate it.